Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, how do students with disabilities prepare for post-secondary education and obtain appropriate accommodations?
Once a student is at the post-secondary education level, there is no legislation that entitles students to the same level of academic support that students receive in high school. This means that if a student has an individualized education program, or IEP, Section 504 plan, or any accommodations or modifications, they will not necessarily transfer into the college setting. Many students mistakenly believe that their IEPs will entitle them to similar services in college. While the IEP is a legally binding document in high school, it has no legal power at the post-secondary level. Actually, the determination of disability status in college is different than what it is in high school. Colleges have their own eligibility criteria for determining whether students have a disability that can be accommodated within their classrooms. This is based on the definition of disability in Section 504 of the Rehabilitation Act. Unlike high school, at the post-secondary level, students are responsible for seeking out disability services. In college, students are responsible for themselves. Professors are not responsible for identifying a student's disability. Moreover, professors will not communicate with school counselors, administration, or family members on the student's behalf. Further, students cannot rely on family members to help them get support for a disability in college. Rather, students have to advocate for themselves and seek out help if necessary. In particular, this includes getting the college to recognize a student's disability and accommodate it. Post-secondary programs may request documentation of a disability. If a person uses a wheelchair or is blind or deaf, no further documentation may be necessary by the college. But for students with a less visible or noticeable disability, such as learning disabilities, mental disorders, or chronic health conditions, it is reasonable and appropriate for a program to request current documentation to establish the validity of the request for accommodations and to identify the accommodations that may be needed. If post-secondary school students do not require any accommodations, they can choose to keep information about their disability private from the school. However, if they do need accommodations because of their disability, students must disclose the disability, as a post-secondary program cannot provide any service, modification, or accommodation when it does not know one is required for the student. This process is often facilitated by an office for students with disabilities, which works with the student to make reasonable modifications or provide appropriate services in a timely manner. A post-secondary program may not discriminate on the basis of disability. It must ensure that the programs it offers, including extracurricular activities, are accessible to students with disabilities. Post-secondary programs can do this in a number of ways. For example, by providing architectural access, providing aids and services necessary for effective communication and accommodations, and modifying policies, practices, and procedures. Further, post-secondary programs must establish a process for making their tests accessible to people with disabilities. Examples of appropriate accommodations may include allowing a student extended time to complete a test or providing a distraction-free space, sign language interpreters, readers, or alternative test formats. Testing accommodations are also required of agencies which administer college entrance exams and the agencies, organizations, or businesses that administer licensure or certification. A school's 504 coordinator, as well as an ADA coordinator or disability services coordinator, are employed by the school to assist students when they feel that the school is discriminating against them. Additionally, each school will have informal and formal processes for dealing with discrimination complaints. In formal cases, the college will have a grievance procedure so students can voice their perceived discrimination and receive the fair and prompt resolution of their concerns. If a student chooses to not use the grievance procedures from the school, the student can still file a complaint with the Office for Civil Rights in the U.S. Department of Education or in a court of law. If you or your child have experienced disability discrimination in post-secondary education, it is important to ensure that the school follows their appropriate process. If you have any questions about your rights or accommodations regarding anything regarding disability discrimination in post-secondary education, please feel free to give me a call.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at lmacdonald@mayalaw.com, and please visit mayalaw.com for more information.